Please proceed.
All right. What this bill deals with is the fact that right now there is a practice in this state of bringing lawsuits against businesses that have a possibly very technical violation of the rules under the ADA. Technical, by that I mean a sign that's an inch or two lower than it's supposed to be, or striping in on a parking lot that's either faded or not quite in the exact same spot. And unfortunately, the way the rules, or the way the law currently reads, is no notice is required to be given to the business owner of the fact of the non-compliance. An immediate lawsuit can be brought with no opportunity for that individual to attempt to make a cure before the action is commenced, with the ultimate possibility of there being attorney's fees and other costs assessed against that business, even though they do ultimately comply with the statute. So what this bill would do, in a nutshell, is require, without removing any remedy, without interfering with the actual fee shifting arrangements or the ability of the attorneys who are representing plaintiffs to obtain those fees, it simply is a notice provision. And what that notice provision does is requires that before bringing a lawsuit, a notice be given to the business with the opportunity to make a cure. And part of what this does is, at least in our opinion, it will actually help the disabled community, because it will get people to actually fix things if they really want, if they're really intended to fix it. And if they aren't, they're going to get sued anyway. And the idea is to smooth the process and actually make it better, in that maybe a business is unaware of the fact that there is an architectural barrier there. Most small businesses aren't engineers. They can't measure the slope on a ramp. There are a lot of issues where they might not even be aware that there is actually a violation. And to provide a mechanism that allows them to receive that notice and to take immediate steps to cure would seem to be better public policy in trying to remove these barriers, which is what everyone, I believe, intends to do and intends the law. So I have several people here.
Patrick Baker.
Patrick Baker.
Jeff Rice.
And Jeff Rice. And I'll just turn it over to them at this point.
Thank you, Senator and Mr. Chair, members of the committee. My name is Patrick Baker. I'm the Director of Government and Institutional Affairs for Greater Mankato Growth. That's our Chamber of Commerce and Economic Development organization serving 1,000 members in Greater Mankato. I'm honored to be here to support Senate File 1407, sponsored by Senator Ralph, and to speak about the importance of passing legislation to help prevent abusive lawsuits that we've seen targeting small businesses in our community. Our organization is aware of nearly 70 businesses that have had suits filed against them in the Greater Mankato region alone. And this continues to be an ongoing issue, as 3 other businesses were served lawsuits just last week. The vast majority of the businesses that have received lawsuits in our community are small, locally owned establishments that were served summonses for issues that can easily be corrected. Most often, the alleged violations relate to parking signage and striping. That's generally because the individuals filing the suit will literally drive by a business and note any issues in the parking lot that could be subject to a lawsuit. There usually is not an attempt to actually patronize a business on behalf of the plaintiffs, and in most every case, the first time a business owner hears of any accessibility issue with their business is when they are served a summons. Testifying after me today will be Jeff Royce, a business owner in our community who will share his experience with these lawsuits. But here are just a few examples from our community. One business owner had his accessible parking signs stolen. So he took the signs from a less frequently visited business that he also owns to replace the stolen signs. Meanwhile, the businesses whose signs he borrowed from was sued before the replacement signs could arrive. In another case, a business had just recently repaved their parking lot and were sued before they could put their new accessible parking signs back up. In both cases, once the violation was corrected, the suit was not dropped or dismissed. From our experience with the small group of individuals filing these suits, it is clear that they primarily seek to secure attorney settlement fees over helping achieve greater accessibility for disabled individuals. In Greater Mankato, the average claim settlement ranges from $5,000 to $10,000, usually just enough to make it less costly for the business to settle versus hiring a lawyer to defend themselves. These settlements can often create a financial hardship for these businesses, and in every case, the money generated for those involved in these abusive lawsuits could be better spent addressing compliance issues. Our businesses have the common goal of ensuring that they are compliant with the ADA and the Minnesota Human Rights Act. They want to be accessible to all of their customers. That's why Greater Mankato Growth has partnered with the Minnesota State Council on Disability to provide access resources and audits to our businesses so they can take proactive measures to be in compliance with the law. But it is critical that these abusive lawsuits be stopped. We appreciate the work the legislature did last year to pass legislation to provide for an affirmative defense and a voluntary notice letter. However, this has not been sufficient in stopping the suits. The legislation proposed by Senator Ralph would help ensure that businesses are notified of an access violation and have an opportunity to correct it before a lawsuit could be filed. I thank you for your support of 1407 and would be happy to answer any questions. I'll turn it over to my colleague, Jeff Royce.
Thank you, Mr. Baker. Mr. Royce, would you identify yourself for the record?
Yeah, my name is Jeff Royce. I'm a proud native of Mankato, and my wife and I opened a hair shop called Baxter's Hair Shop in 2014. We went through the process of kind of looking at the market, and a couple of the things that we did when we built out this hair shop in the strip mall was we literally placed wash bowls at every single station so it would be easier for people not to get up and have their hair washed, but literally did it at every single station so it'd be easier for everyone to get their hair washed during a consultation and style. The other thing we did is we built a private room so that people that may have a medical condition like cancer or a religious concern regarding their headwear in front of people would be more safe and secure in this environment in a private setting. So we went kind of out of our way and spent more money to allow these accommodations to have people get not only a better service, but just an easier way for our stylists to work. So we put these wash bowls in, and when we built the facility out, we went through an architect, we hired a designer. When the facility was complete, we went through the local building officials and got approval for our building. And in the building code, there are provisions for the MHRA and obviously the ADA. So we got it all signed off. So we had been in business about 2 years, and all of a sudden one day we were served with a lawsuit that said a person who was a customer of ours found that literally a storage cabinet that was on wheels was blocking the door to the restroom by a couple of inches. Okay, didn't prevent them from going to the restroom, just literally blocked the door by a couple inches. So we were served the lawsuit. Our manager obviously just moved the storage cabinet to the private area, and we thought it would be done. So we had to hire an attorney, obviously, and we motioned for that complaint to be dismissed. So to go one step further, I thought, and along with the advice of my attorney, let's hire an ADA expert just to make sure that there's anything else. I want to make sure that we're in compliance. So we hired Julie Corvey-Peterson out of the cities here, and she came down and inspected our facility along with several others. And she did find a couple other things. So she found that our coat rack was a few inches too tall, our service counter was a few inches too high, and the restroom signs that were, we didn't have valid restroom signs that included some, braille on them. So we put in some plans in place to resolve all of those issues, and obviously continue to seek the dismissal of the original lawsuit. So the plaintiff came back and took pictures now of things that we already knew were a problem, and amended their lawsuit to continue the suit going on. So we knew that the counter was too tall. They pointed that out along with these other violations. So the attorneys did the inspection. We fixed the service counter, so we spent like $700 just to get it done real quick. We lowered the coat rack, easy fixes, installed restroom signs, and again, motioned for the lawsuit to be dismissed. So then evidently, and I, again, we had the AD expert in. They pointed out that we had a toilet paper dispenser that was mobile, right? So anyone could use it. You know, it was movable. So evidently that was a question mark. So they amended the lawsuit again, included this toilet paper dispenser. So I'm not a real handyman. You're not going to hire me to do a whole lot around your house other than maybe rake the leaves. But I installed the toilet paper dispenser myself and making sure that it fell within the correct measurements of the ADA and the MHRA. So we've gone through all this work, and it continues on. And my attorney bills so far, I think, are just shy of $6,000, and the total cost for the fixes is far less than $1,000. And all I'm asking for is I think this bill does serve notice. Our desire is obviously to provide a facility that meets all the requirements, but quite honestly, as you can tell, it's very difficult. And so, you know, if a business can fix an issue within a reasonable amount of time, I think that would be great. You know, we want to do the right thing. Our stylists want to serve all people with any accessibility issues. They're trained to hold the door open. They're trained to go the extra mile, and they're trained to take their time. So in my opinion, this is something that we could all use in the state of Minnesota. This has obviously affected me and our business. But at the same time, I think it's just good practice for Minnesotans. We're called Minnesota Nice for a reason. And I think there's a way to resolve these issues in a far easier way. We are still held accountable. I don't want to shirk that responsibility at all. But at the same time, I think it could be easier for us to resolve these issues with the passage of this bill. So thanks for your time, and more than welcome to answer any questions. As long as you don't ask me to cut your hair. You all have very nice hair, but I am not a hairstylist myself. You don't want me, if you see me with a pair of scissors, run.
Thank you, Mr. Royce. Flattery will get you everything, but maybe with the exception of the Judiciary Committee. Mike Hickey
Mr. Chairman.
From NFIB.
Mr. Chairman,
Senator Latz.
at which point in the process here would you like us to ask questions?
I'd like
of
to
the
get through our
testifiers?
lengthy list of testifiers. What we could do after we go with the proponents, if you have a short question, we could, but I want to get back to our list.
Thank you.
What would you choose to do? Would you like to ask a question of proponents when their section of time is over? Or would you wait until all of the testifying is done?
I'll hold my questions
All
until
right.
the testimony's done.
Mr. Hickey. Would you identify yourself for the record?
Mr. Chairman, Mike Hickey with National Federation of Independent Business, and I want to speak in support of the bill today. I want to thank Senator Ralph for bringing this bill forward. This is a problem that clearly needs to be fixed, and this is some of the worst lawsuit abuse we've seen in a long time, and the last two examples are very compelling, and I have a few more, and I'm sure you've heard many, but we know of at least 300 suits have been filed to date, and that's probably understating it because many people were pocket served and the cases have not been filed in court yet. As you know, Mr. Chairman, we represent a large number of small businesses, about 11,000 at the moment. I feel like right now any one of them is a virtual target, you know, and we have serial lawsuit abusers going around our communities, and a big part of this motivation is under Minnesota's Human Rights Act, you can sue for monetary damages, and you can make a monetary ask, where you can under the ADA. And there's been lawsuit abuse under the ADA also, in some people's opinion, but I doubt it was to this extent. And under the ADA, you can get your attorney's fees, but you're suing for what's essentially proactive injunctive relief to make a business, correct a barrier. And I don't think we've seen abuse quite this bad under the ADA or not close. But these examples are very telling. A couple that I just recalled, a doctor doing some great work in South Minneapolis for low-income patients was sued because the front threshold step was 1 inch too high. Had a situation where the Bulldog, it was kind of a high-profile case, Amy Rowland and the Bulldog was sued just because the tables, the height of the tables weren't in the right spot, according to the plaintiff. Well, obviously, what's easier to correct than move some tables around? Probably corrective action could occur in a few minutes. And finally, this has even hit our board members, Mr. Chairman. A member of ours was sued last week, and he wished he could be here today to tell you the story. And one of the claims was their sign for disabled parking in the parking lot was about a foot too low. So a lot of this is just ridiculous in our opinion, and these suits should not be going forward. And so I really appreciate what Senator Ralph's doing. He's trying to finish the job of last year, and as you know, this bill allows notice and corrective action by the defendant, and if they refuse to do that, then they can be sued. And so it really is not making a very dramatic change at all in our current law, but it's giving people ability to correct the problem and stop some of these ridiculous lawsuits. These problems can be resolved much more quickly and in a rational manner without people being facing a lawsuit. So really urge you to act on this bill this year.
Thank you, Mr. Hickey. One other person was added to our list as a proponent, Mike Rodenbaugh from St. Paul. Welcome to the committee. Would you identify yourself for the record?
Yes, thank you, Mr. Chair. My name is Mike Radenbaugh. I own and operate Park Liquors on Snelling Avenue in St. Paul. It's just 1 block south of O'Gara's. This past September, my business received a summons and a complaint stating that I was out of compliance with the ADA for not having my parking lot properly striped. Similar story to what you've been hearing all day here. Until I was given that notification, I had no idea that I was out of compliance, so I contacted my MLB rep, Tony, and he gave me the name of an ADA consultant, the same lady that the gentleman from Mankato used. She visited my store the next day. She showed us how to remedy the situation, which we did within the week for a cost of $250. We also had to inspect the rest of our store for any other violations. She said countertops were 1 inch too high, so we took a Sawzall and chopped them down 1 inch and got them in compliance as well. The infuriating part of this whole experience was that even though we quickly brought our property into compliance with the ADA regulations, we could still not get the lawsuit dropped. We were told that we could go to court and most likely win, but the estimated litigation fees were going to be an amount that was double what we ultimately settled for. So what cost me $750, or what should have cost me $750, ended up costing me 10 times that amount. As a small business owner, that was really a painful check to write. That money we had earmarked to install LED lights in our store, upgrading our property, making it greener, and now that project just got kicked down the road a year. I've owned the business for 25 years, and we were completely unaware that our parking lot, which is only 10 spaces, was required to have 1 designated spot for handicap parking. I realize that ignorance is no defense here, but I do have clientele that are in wheelchairs, and they never complained to me one time. And the City of St. Paul fire inspectors, building inspectors, they come by every year. No one ever said anything about our parking lot needed to be striped. So if a piece of signage is out of whack by a foot or an outlet needs to be moved, we get a 30-day notice to take care of the problem. They come back, it's fixed, it's all good. The fact that there's no remedy window in the ADA laws seems highly punitive and open to abuse. Now, in my particular case, the plaintiff lives a few blocks from where we sit today. My store is 3.5 miles from here. So by my estimation, there's over a dozen liquor stores between his place of residence and my store, and he does not own a car. So he claims that one day last July, he came to my store, seeing the lot was not striped for handicap parking, his sense of independence was negatively impacted. I have no way of knowing if he was actually in my parking lot, but if he was, I have my suspicions that he happened to come there that day to make a legitimate purchase. I've heard that the plaintiff lawyers involved in these cases will sometimes even drive the plaintiffs to the locations themselves solely for the purpose of filing a lawsuit. And these serial lawsuits are an ongoing drain to the small business community. And my understanding is that a handful of lawyers are responsible for a majority of these drive-by lawsuits. This is even a national issue. I don't know if you've seen the Anderson Cooper segment on 60 Minutes recently, and locally we have an attorney that the FBI has been investigating since December for filing these disability access lawsuits. In short, this altruistic statute has seemingly created some unintended pitfalls. I realize that asking you to consider amending the state statute will in no way change what happened to me. My hope then is to spare other small business owners the pain of being put through the same experience. Thank you for your time.
Thank you. We'll be moving on to an opponent. Mr. Carlson is needed in another committee, so we're moving him up the list. Mr. Carlson, would you approach the testifying table? And would you identify yourself for the record?
Thank you, Mr. Chairman and members. Joel Carlson. I'm here on behalf of the Minnesota Association for Justice, and I'm certain that the Mankato hairstylist was not referring to me when he was talking about all of you having lovely hair. Mr. Chairman and members, we have some concerns about how the legislation is drafted, and I want to make sure that you know that the concerns are based on what the language says. We're not here to defend the lawyers on either side of these cases, because our association has concerns, just like everybody at this table, about some of the activity that we've heard. We find it particularly troubling when you have businesses having cases filed against them when they don't know of an issue under the ADA, obligations that we've had for some 27 years. We don't like hearing that businesses are settling cases when they are not in violation of the ADA, and we've heard those stories as well, and we think that's wrong. I mean, we can't defend the lawyers on either side of these cases, but what we can defend and what we need to defend is the rights of the disability community to have their day in court and to be able to bring forward legitimate cases so that they can have safe and adequate access to public accommodations, which is what the American with Disabilities Act and our Human Rights Act intended to provide for them. And we're not there yet. I'm going to make just a few comments about the bill, and then I want to make sure that we understand one last thing. Everything that we do here right now relates to claims that are filed under the Minnesota Human Rights Act. We are not going to change or address the federal American with Disabilities Act, where many of these cases can and are filed in federal court. So whatever we do here, we may have the unintended consequence of just pushing these cases into federal court because the restriction does not apply. So I want to make certain that we utilize our state courts to have these cases resolved quickly and efficiently and not have an unintended consequence of saying, okay, I can't do anything under Minnesota law, I'm just going to bring the action in federal court. Because we're not changing those requirements under the federal ADA. To the bill itself, Mr. Chair and members, I'd like to at least point out a couple of issues that we see. And the first of those is on lines 1.11. You'll notice now that the reference here in this notice is to 63A11 subdivision 3. But the notice requirements of the bill that we passed last year, which is in subdivision 1, which is not on the printed page in front of you, only deals with violations under 63A.11 subdivisions 3, subpart 4 and 5. And that's important. The reason that's important is those are the claims that are related to making physical changes to your property. Many of the complaints that you hear about striping of the parking lot or the level of the signs are not covered by the existing law when you read subdivision 1 of this section. It only applies to subdivision 3, subparts 4 and 5, which is physical, changing of physical barriers. So as this bill moves forward, we should talk about how we want to differentiate between those items that require a physical alteration to a public accommodation and those items that require what we will describe as simple fixes, the striping of the parking lot, the moving of the sign, mounting of the toilet paper holder at the right level. As I read this right now, we're scooping in everything under one rubric, and I don't know that that's really what we want to do. And we didn't do that last year, and it was deliberate. So I think we really need to think about what kinds of cases we want to make certain we're putting additional controls on. You know, and as we talk about controls, it seems to us like the biggest issue is on the behavior of the council and not on the right to the access to the public accommodation. And that's one of our concerns. We're not addressing the behavior that we maybe dislike. we're taking the rights away from everyone who don't have these kinds of problems. So when you look at page 2 of the bill, as we read it, you are unable to file a civil action, and this is problematic. You're unable to file a civil action against a public accommodation if they tell you they've removed the barrier. And what that does is it eliminates the ability for people to bring claims for past violations. And while we maybe don't think that that's important, that's how people are able to be represented. And so if I can insulate myself from ever being sued by sending you a notice that I have solved the problem, no one is going to be able to be represented under the Human Rights Act under these kinds of architectural violations. So I worry about that. The second part of that provision allows them to tell you and certify to you or from some other professional that I don't have to comply. And that means not that I litigate over my claim, I litigate over what an expert said as to whether or not I complied. And while that may be part of the litigation, as a condition precedent to getting to court, we think that that is an unintended consequence that we'd like to see the language more clearly address. And lastly, in that section, it talks about the timing of bringing about.
Mr. Carlson?
Yep, I'm sorry, Mr. Chairman, I'm sorry.
Do you have a line that you're referring to?
Yep, I do. Mr. Chairman, saying that I am in compliance is lines 2.5 to 2.7. Producing the architectural audit is lines 2.8 through 2.11. And then this is the one that's most problematic because you allow the business to decide whether or not they're going to come into compliance, and that's 2.12 to 2.15. And those three segments can be problematic for people that are bringing these claims that have been denied access, that want to seek redress under the Human Rights Act. You know, if we're going to have a notice, I would prefer after the notice period has run, right now it's 30 days. If you look back, Mr. Chair, members, on lines 1.17, right now the time to respond is 30 days. After 30 days, the aggrieved party should be able to file their case in court. And that does not, if you just make that change alone, then the person will still have their claim for past violations, which are currently allowed, and you won't change the incentive so much that the people will actually be represented and will do the investigations and bring these cases forward. So, Mr. Chairman, happy to work with Senator Ralph as this bill moves forward, but I think it's a work in progress and we're not quite there yet. There are other states that have wrestled with this that have not gone to this extreme, California being the most notable example. They've had more cases than anybody in the country. So we think there are things that we should be talking about and putting on the table without going to this particular measure, which I can't find in any other jurisdiction. Thank you, Mr. Chair and members.
Mr. Chairman,
Thank you, Mr. Carlson. Senator Latt.
because Mr. Carlson has to leave for another committee, may I inquire of him
Yes.
at this time?
Please do.
Thank you, Mr. Chairman. Mr. Carlson, you made reference to the 30-day response time on line 1.17. Could you explain to me once again why that was so problematic?
Mr. Carlson.
30 days is, say, the wrong number.
Mr. Chairman and members, when we agreed to the 30-day provision last year, because the notice was not a mandatory notice requirement, we felt that that was an adequate period of time to get a response back. If we're now going to flip this to a mandatory notice requirement before I can have access to the court, we would probably suggest that 30 days is too long, that you're on notice. But if I'm going to proceed with this, you know, the 30 days might be too long. And what we don't want is, if you look at the timing of this, you can't do anything for 30 days. And if you look at lines 2.12 to 2.15, then I can't do anything within 120 days. All the while, someone is working on a file And then if they complete that, then I can't file a case at all. And that takes away any ability to bring an action for past noncompliance, which is the remedial nature of the ADA to begin with.
So, Mr.
Senator
Chairman,
Latz.
so essentially it's kind of a get-out-of-jail-free card, essentially, Mr. Carlson, and I'm using that only because it's a common reference that we all know from the Monopoly game, but so no other intentions by the analogy. But essentially, you can commit the violation. If someone finds out you committed the violation, they can tell you committed the violation, and if you fix it, you would absolutely face no liability whatsoever. Is that the way the language is written here, as you interpret it, Mr. Carlson? Or is it they would not be barred? Would they be barred from filing a lawsuit, or just as a practical matter, a lawsuit could not proceed because the violation was already remedied and there'd be no damages that could be obtained? I guess I'm asking, what does the language say in the bill?
Mr. Carlson and Senator Ralph, if you want to join in this conversation, you're welcome to. But Senator, or
We're
Mr.
comparing notes.
Mr. Carlson.
Mr. Chairman and members and Senator Latz, I believe if you look on lines 2.2, you will see that a civil action may not be filed or pursued if the public accommodation meets these requirements. So it's my feeling that if they comply with paragraph D, that I cannot pursue a claim. That's how I read that, and maybe that's not intended, but I don't know any other way to look at that.
Sir Ralph?
Thank you, Mr. Chair. Senator Latz, I think the intention here is not to deprive someone of a legitimate cause of action. There's two purposes, I believe, if we look at this, and I can ask some of my testifiers to come forward as well, but I think there's two purposes. Number one is to get the thing fixed, and this provides a path to do that. Number two is where it is fixed, then the question becomes is should there be any additional penalty to the business? And I believe this is part of the concern that we have, and I have to express that I have been speaking, and I don't know if Mr. Elwood is in. We've been speaking from legal defense or legal aid, and want to move forward with working on language that addresses both of these issues. Unfortunately, with time deadlines, we need to move forward. And I believe that all the stakeholders are certainly committed to getting language that is going to protect the legitimate claim, especially where someone can show actual injury, and to protect at the same time the businesses from these predatory lawsuits. And there's no question that's what's going on here. People are finding excuses to bring a lawsuit simply because they can collect attorney's fees. And I am told, and unfortunately was not involved in this in the prior legislative sessions, but that this is a work in progress, and we're getting closer, and I think we're committed, all the stakeholders are committed to come up with language that protects both sides of the equation. But the intention is not to remove a cause of action. To Senator Latz, your point as to should there be some consequences for a violation, as I understand the ADA, there are not specific penalties for having a counter that is too low or for failing to stripe the parking lot. And this may be part of the problem, is that there's kind of an open book here and people can do just pretty much anything they want. So the object here is to try and provide a vehicle that will get the job done, that will get the barrier removed, which is what I think everybody in the business community wants to do. If there's a barrier there, we want to remove it. And so that, with that, I guess that's kind of summary of what the intention is.
Senator Latz.
Mr. Chairman, I guess the more focused question I asked had to do with what the language in the bill actually does, but Senator Ralph has raised another issue of great concern to me, which is, and I've heard this in repeated committees this year, this bill is still a work in progress. Just pass it out of here so we can keep it moving along because we got deadlines coming up. And I hope that this committee doesn't go down that road here where you've got a bill that says, well, we're still working on the language. We'll send it off to some other committee that doesn't have the jurisdiction to deal with this particular language, and we'll let others deal with our issue. So, but we can address that, I guess, in a moment. But as I'm understanding the intent of the language in the bill, if you read on page 2, paragraph C at the top, basically it says if you fix the violation, no lawsuit can follow. Right? Civil action may not be filed or pursued by the plaintiff. And then if you go down to paragraph D on line 12, you can have more time to fix it if you get an accessibility audit that says you're going to get it fixed. And then you can't pursue your lawsuit for at least 120 days. Presumably then, if you fix it within the 120 days, you get referred back up to paragraph C, Clause 1, which says if you fix the barrier or the violation, then you can't file a lawsuit. So either way, if it gets fixed, presumably within 120 days at least, you can't file a lawsuit. So the question for me at that point is not necessarily, is there a damage provision in the statute? The question is, I think Mr. Carlson was alluding to this concern, is how is a lawyer supposed to earn a living pursuing violations of the ADA if at the end of the day they can't bring a lawsuit, they can't get their attorney's fees covered, and basically they can't do anything to bring a claim to enforce the law? So essentially what this bill is asking lawyers to do is pro bono assist in identifying violations, sending out notices, and presumably they have to do some due diligence before they'll even do that, or they're violating Rule 11. Incur fair amount of pro bono attorney's time, and in the end, if the violation is fixed, never be in a position to recover their fees. In other words, they'll never do this, which is to say no one is going to do this unless they receive a grant from some charitable organization to go around trying to find violations. Now, we may agree that many of the violations are fairly small, but if restriping a parking lot isn't just a matter of are the parking spaces wide enough for everyone, but rather there is no handicap spot at all in the parking lot, that's not a simple matter of restriping. But in either case, you've got a situation where there's no financial ability for a lawyer to represent a client in pursuing these violations. Now, the whole Human Rights Act is set up under the premise that most clients are not going to be of financial means where they can pay a lawyer an hourly fee to pursue remedies of violations of the ADA or any other provisions in the Human Rights Act. That's why they have the fee-shifting provision in the Human Rights Act in the first place. And so I'm trying to read to the allusion that Mr. Carlson made, but if he said that's why, I assume it's the reason he said you'll never be able to pursue this because lawyers won't be able to cover their costs or expenses or time in representing clients to pursue these violations. Now, I see people nodding, Mr. Carlson nodding his head, so maybe I understood that correctly.
And, Mr. Chairman, when you go back and look at when the ADA was adopted in 1990 and signed by President Bush, and you look at some of the committee notes, you'll notice that the attorney fee shifting provision was a very important component of the ADA because it was the tool that allowed the disability community to assert their important civil rights. And so I think this takes us too far away from that by putting essentially the defendant in the position of deciding whether or not I get to go to court. And that goes too far. And we do think it will be difficult to obtain counsel the way that it is currently constructed.
Members, we still have a number of other testifiers that wish to give testimony, and I'm going to move us on.
Thank you, Mr. Chair and members.
Mr. Elwood, Ron Elwood, and while they're coming up, would Senator Ralph, did you want to make a comment as the other testifiers?
I can wait till I was going to respond to some of Senator Latz, but in the interest of getting the testifiers on and get heard, I'm sure we will continue the discussion in committee, and I am comfortable with doing that.
Thank you, Senator Ralph. Mr. Elwood, welcome to the committee. Would you
Thank you,
identify yourself for the record?
Thank you, Mr. Chair and members. Ron Elwood with Legal Aid, and I'm also speaking on behalf of our one of our statewide projects, the Minnesota Disability Law Center. First of all, I just want to thank Senator Ralph. We've had conversations on this bill, and he's reached out, and I'm really appreciative. And I think we all share the same goals. I'm not going to reiterate the points that Mr. Carlson made. I will note that he took the joke that I was going to say about the hair cutting away from me, and I'll deal with him later on that. But the issues that have been surfaced, I think we share them, but I also think that we all share the same goal, which is accessibility. You know, it's your call here, of course. You don't need me to tell you whether to, kind of noodle it here or move it along and let the parties work together. I just want to say that last year it's a very similar situation. We got a little further, I think, in committee than we are last year, but it wasn't the final product. And I just have to say that the Chamber and the Minnesotans for Lawsuit Reform and the Minnesota Association of Justice and all the state agencies, I think we all did work together in very good faith to get to a place where we did have a consensus at the end. Some were more favorably inclined to it than others, but everybody supported it. And so, I just don't have any reason to believe that anyone would act differently this year. I think there's a lot of good faith among the parties to try to balance the interests of preventing some of the problems that you've heard are continuing that we all think need to be addressed, but also not throwing out the baby with the bathwater.
All right. Thank you, Mr. Elwood. The next individual is Mr. Scott Butel. Mr. Butel, welcome. Would you identify yourself for the record?
Good afternoon, Chair Limmer and members of the Judiciary Committee. My name is Scott Butel. I'm the Public Policy Director for the Minnesota Department of Human Rights. I'm here today to testify briefly on Senate File 1407. The Department has some concerns about the bill as it's currently drafted, and we hope to be able to work with stakeholders and the authors as this proposal moves forward to continue to improve the bill.
Mr. Butel, could you talk up just a little louder?
Yes, Mr. Chair. We worked with Representative Smith and Senator Dietzig last year on this issue when House File 2955 was ultimately signed into law, and we remain interested in this issue. For brief background, as part of the Department of Human Rights work, we investigate claims of discrimination, including disability discrimination. Disability discrimination is our most common type of case before the Department of Human Rights, comprising approximately 30% of our cases. This is a growing proportion of our work. The U.S. Census reported in 2012 that 1 in 5 people in the U.S. have a disability of some sort, with research suggesting that an even greater percentage of individuals will experience a disability at some point in their lifetime. As our population ages, this percentage will climb. Disability touches all of us, including all demographic groups and communities. Accessibility to business and other community gathering spaces is a key element to ensuring that all members of the community are able to fully participate in our shared public life. I think this general background I provide this general background information because we believe it's important in thinking about specific questions of disability accessibility to think about this bigger picture. The bill currently would create a mandatory demand letter with an opportunity for a business to cure a violation without liability. We are concerned this potentially creates a barrier to legitimate claims while also possibly disincentivizing businesses proactively improving architectural accessibility as required by law. We are also concerned about possible spillover of this new standard in the bill to other types of disability claims or possibly even other civil rights claims. To raise just a couple of very specific points, the point that I believe Mr. Carlson raised about line 1.11, about 363A 11 subdivision 3 being broader than it was in last year's bill. In House File 2955, the third engrossment, which was the version ultimately passed and signed into law, the clause, for the limitation of that to clauses 4 and 5 only was on line 2.11 in that bill. We appreciate that on line 2.29 of the current bill that charges filed with the Department of Human Rights continue to be exempt from these proposed divisions. That was something that was discussed last year, and we appreciate that this continues to be in the bill. We intend to work with the bill's author, proponents, and stakeholders within the disability community to help ensure that the final proposal really helps to realize the promise of accessibility to individuals with disabilities in our community. Thank you.
Thank you, Mr. Butel. Mr. Shardlow.
Good afternoon, Mr. Chair, committee members. My name is George Shardlow, and I serve as the Legislative Coordinator for the Minnesota State Council on Disability. For 43 years, Ms. Scott has served as the state's resource on accessibility. Last year, we worked in partnership with the Chamber and other stakeholders to pass a compromise bill, which would be augmented by the bill before you today. And in the spirit of Minnesotan conflict avoidance, we do not come before you to oppose or propose per se, but talk realistically and with some sobriety about what the regulatory landscape this would take us into. So first off, I want to thank Senator Ralph for bringing this forward. The disability community is hurt by this too. If resources are going to be spent, we want them to be spent removing barriers. But we all know that there's one law that governs everything we do here, and it's the law of unintended consequences. And I think the bottom line, and this is, I believe, what Senator Latz was starting to get at, is the work needs to get done. The issuance of demand letters needs to be, someone actually needs to issue the demand letters. And as it is now, there's a mixture of pro bono work. We offer some assistance as our capacity allows on this. And in some cases, there's a private sector legal market that can help in the issuances of these demand letters. And so we, as I spoke with staff and other internal stakeholders, I think as this debate has evolved, we at least initially were not opposed to the idea of a mandatory demand letter per se, so long as there is an adequate supply of readily obtainable demand letters for individuals with disabilities. I think the other, Mr. Carlson and Mr. Elwood and Mr. Butel covered a lot of the structural issues I was going to highlight, but I guess in closing, I would say three things. First off, as you heard earlier, Minnesotan business owners are eager to comply if they're empowered with the information. We at the council get to see that firsthand. But I think you also heard the fact that there is work that needs to be done. It's troubling to me when I hear that there are business owners engaging with regulators and hearing that they are in compliance when they are not. And part of that has to do with discrepancies between the ADA, the state building code, the fire code, and what have you. But I guess I would say that it's our preference that this bill came in conjunction with more work to clarify the administrative enforcement of some of these accessibility proposals. And so I want to close by, again, thanking Senator Ralph, thanking all the stakeholders who have been working on this for 2 years now. But just maybe end on the note that I do have to acknowledge that I'm here to represent a community that has been waiting 27 years for the state to be fully accessible. And so I'll be candid and say I think that there is some reticence in the community if we find ourselves in a position passing a bill that constricts litigation-driven enforcement without making more robust administrative enforcement. So as others have said, we look forward to working with all stakeholders involved, and thank you for the opportunity to testify.
Thank you, Mr. Chardlow. We have one more individual who has yet to identify themselves by name, but I understand there was a person. Apparently, there's more than one. Why don't both of you approach the table and for a brief comment, and then we have to move on to our discussion.
Probably really don't need this microphone. But
Well, good afternoon. Thank you for coming.
Mr. Chairman, my
Would you
name-
identify yourself for the record?
My name is Mark Hughes. I want to thank Senator Ralph for bringing this bill forward, and I'm not going to sway it either way. I just wanted to give you a brief background. A year or two ago, up in White Bear Lake, we have an office building. I'm an Osmond Shriner in St. Paul. We have to have a Blue Lodge. The Blue Lodge for me is White Bear Lake. We have a building up there whereby in White Bear Lake, I had belonged to the White Bear Lake Chamber of Commerce, still do, and we had an attorney, Lensmeyer, from Minneapolis, who you read about in the city pages and the newspapers, and was on Fox 9. Well, he had brought up some predatory lawsuits. Our building didn't get caught at it, but for example, he went to Washington Square, which has a pretty good restaurant in it, where you get breakfast and hamburgers and such. It always had, Washington Square always had, a disability entrance on the side of the building, which was a long piece of concrete, but it was always cleared. You could get in and out of it. We had met there many times, but in the front, there were steps. So Lensmeyer went up the steps and decided the place didn't have a accessible entrance, which it did on the side. So he'd file all these predatory lawsuits, and we had a bunch of them too. So my point is, I don't want Mankato to feel all alone. We went through this for a couple of years in White Bear Lake. Well, it wasn't fun. We've now renovated our building, even though we weren't caught in a lawsuit, but we sure know about it. We're up at the White Bear Lake City Council, and Fox 9's Tom Lydon did quite a story on it, and now they've got Lensmeyer. I guess the Fed's caught up with him. He's in the federal prison, so we've taken care of that thing. But I just don't want to see Mankato go through what we went through in White Bear Lake, and I thank you for this time. And also, the Minnesota State Council, that's what they're for, is an advisory to when you get into situations like this. And I'm a 12-year member, which by state law is all you can serve, and they've done a great job over there, and I hope to continue. Thank you.
Thank you, Mr. Hughes. Sir, would you identify yourself for the record?
Thank you, Mr. Chairman, members of the committee. My name is David Katroser. I'm a practicing neurologist. I'm a practicing attorney. I'm on the Met Council's Equity Advisory Committee, and I'm testifying today because I think that what Senator Latz was mentioning is not being adequately appreciated by the committee. This law was initially suggested today as a way to avoid lawsuits for minor violations. There is nothing whatsoever in the law that suggests that it is explicit to minor violations. It will have its impact on all violations. The effect of this law is to stop lawsuits. The Minnesota accessibility regulations have been in effect for 34 years. Notwithstanding that, you cannot go one block in any direction in any business district without finding multiple violations. The violations are so extensive that in the city of Minneapolis, where there were about a year and a half ago, roughly 90 surface parking lots unassociated with specific businesses, there were maybe 3 that had a handicap parking space in them, notwithstanding the fact they're all required to. This bill and the one that happened last year put an obstacle in front of anyone being able to bring a lawsuit. They require that an individual, especially with the amendment this year, go to an attorney, get that attorney to listen to their story, do the work, and send out a notice, at which point the business has 30 days to correct. If they even suggest that they have a proposal as to how they're going to correct it, they then have another 120 days. Even if they ignored all of that, didn't do anything, and a lawsuit was brought, then there is an affirmative defense in the law that says that if they then correct it, the case is dismissed. That means that there is no incentive whatsoever for any business that has not for the last 34 years made themselves accessible to make themselves accessible now, because they have a get-out-of-jail-free card at least twice. 1, they can fix it before the lawsuit. 2, they can fix it after the lawsuit. And if they do either, the lawsuit disappears. Lawyers are not a stupid group. They're going to figure out that they're not going to get paid for this. The only people that will then be able to do this are people who can find a pro bono attorney. In other words, my civil rights depend on someone else giving me charity, or my civil rights depend on my being able to buy my civil rights by paying my lawyer. Neither one of those is an acceptable solution to the problem. The purpose of these laws, theoretically, was to stop abusive lawsuits, primarily by one attorney who's no longer a member of the bar. If there really is a goal to stop abusive lawsuits, then what should be done is to say that if a lawsuit is brought and a correction is made, then the most that the attorney can get in settlement is some amount to be determined by the committee, say 1,000, say 1,500, at which point there is no incentive to abuse. But as long as we put an obstacle in front of all lawsuits, that means all the legitimate ones. We heard testimony today about the doctor's office that just had a 1-inch barrier on their entrance. Well, that may not seem much to you, but in a wheelchair, that might as well be Mr. Trump's wall. No, we're not going over it in a wheelchair. So these minor violations are not so minor. A handicap parking space without an access aisle isn't a handicap parking space because I can't get out of my car. I would appreciate, hopefully, that the committee consider that the goal with these lawsuit abuse protections should not be to increase the obstacles for people with disabilities. It should be to eliminate the abuses. Thank you.
Thank you, sir. We'll now open it up for committee discussion. Senator Latz?
Thank you, Mr. Chairman. So there's a common theme here, at least among testifiers, that it appears that on line 1.11, maybe there needs to be some narrowing of the reference to subdivision 3 to specify clauses 4 and 5. I wonder if Senator Ralph would consider that to be a friendly amendment. Otherwise, it will capture all of the other provisions in the bill the bill. It doesn't seem to have been targeted by the bill itself.
Senator Latz, you were on the committee last year. I believe our very committee considered and passed in this committee pretty much a substantially identical bill to what's being proposed here, at least in this language. Is there a difference now that you're trying to point out to us that was not included in the bill last year?
Mr. Chairman, I don't have in front of me last year's bill, and I don't recall the detail of it that you may be referring to. But I have been looking at the statutory provisions here, and the reference to subdivision 3, if it's not narrowed down to clauses 4 and 5, makes application to failures to make modifications in policies, practices, or procedures as well. Failure to take all necessary steps to ensure an individual with a disability is excluded, denied services, segregated, or otherwise treated differently because of the absence of auxiliary aids and services. Eligibility criteria that screen out disabled individuals, which is much broader than the architectural barrier references that the testifiers have been referring to. However we did it last year, it seems to me, well, number one, I thought it was done last year. I think a lot of us thought there was a compromise last year. People in good faith agreed to deal with the issue last year. And why are we already back? You know, I think that's a fair question to ask. But the fact is we are back. And I think, I wonder if Senator Ralph would agree that narrowing the reference on line 11 to clauses 4 and 5 is an appropriate narrowing, because clause 4 makes reference to the architectural barriers and communications barriers that are structural in nature in existing facilities, transportation barriers, and clause 5 makes cross-reference to clause 4. It's kind of a follow-up to clause 4. So if we're going to deal with architectural barriers, this would be the way to do it, is to add clauses 4 and 5 as after subdivision 3 on line 11.
Senator Ralph? Do you have any
I'm sorry,
comment?
Senator Latz, I'm having trouble hearing what you're saying. As I understand, what you're saying is that there is, I'm sorry, Mr. Chair, Senator Latz, that there would be some distinction between the nature of the barrier that's involved. Is that what you're saying?
Senator Latz.
Mr. Chairman, on line 1.11, the reference to subdivision 363A.11, subdivision 3, captures 5 subparts, as Mr. Carlson referred to them as. I call them clauses or paragraphs, 1, 2, 3, 4, and 5. But it seems to me that the violations that have been referred to in the testimony, and which I think are fair to target in terms of, you know, the potential for abuse here, are the architectural and related barriers. And those are only dealt with in paragraphs 4 and 5 of subdivision 3. So what I'm suggesting is that we narrow the focus of that down to paragraphs 4 and 5.
Senator Limmer, Senator Latz, I think one of the
Ralph.
things that we should be focusing on here, and I think those are some fine tuning, but I think the thing we need to be focusing on, and this came fairly apparent during the testimony, is that the abuse in many respects occurs not by the fact that there's some kind of a barrier or some kind of a violation, but that if there's been a bona fide attempt to remedy it, or if that the individual who is involved acknowledges and fixes the issue, that the lawsuit continues. And I think that that's something we need to focus on. The other thing that I would comment on is the question of the attorneys being able to make a living, and I understand that. I resemble that remark. I was an attorney for 30-some years in private practice. Frankly, there is a risk already involved in bringing a lawsuit here, and that is that if there is not a violation or the court finds that the violation is insignificant and they have the opportunity to say to the attorney, no, you don't get attorney's fees, as I understand the fee-shifting statute. I think that the idea here is certainly not to take away the opportunity for someone who is unable to afford an attorney. That's the whole idea behind the fee shifting. But there should be some method of limiting that once reasonable steps are being taken, so that if the attorney does bring the action, that they obviously be compensated for the time involved in representing that individual. It's the incentive on the part of the way the statute right now reads is to allow the lawsuit to just continue and continue and continue. And I believe that if we can remove the incentive by, in some fashion, acknowledging that the defendant has either complied or has managed to comply, then that should be some kind of a trigger to prevent further actions to just simply enhance the amount of the recovery. And again, I am open to suggestion. Obviously, I don't have the history on this, but I do understand the abuse and the mechanics that are involved. And again, input from the stakeholders and input from the Bar Association, I think, is important, or from the legal aid is important, in that we try and limit the damage, if you wish, and to enhance the opportunity to, as we've said, take the money that's now being spent in attorney's fees and put it into fixing the barriers.
Mr. Chairman?
Senator Latz.
If we can, I'd really like to keep focused on my particular question, because I know we're going to run out of time if we don't. And I can just offer an amendment and I'll explain it.
Yeah, I was going to ask if you had an amendment.
I was trying to.
Why don't you go ahead?
On line 1.11 of the bill, after subdivision 3, insert paragraphs 4 and 5. And, Mr. Chairman, I did go back and took a look at, I
believe that's clause 4 and 5.
Clause is fine.
Okay.
Clauses 4 and 5. Last year's bill, Mr. Chairman, and current law has a definition section that defines accessibility requirements under law, and it, in that definition, narrows the reference down to clause 4 or 5. The bill before us actually deletes the reference to accessibility requirement under law on line 9, and essentially in its place on line 11 broadens it to all of subdivision 3. So if we want to be consistent with the scope and focus of last year's bill, we will have to insert after subdivision 3 the reference to clauses 4 and 5. Otherwise, it's a substantial expansion of the prohibition on lawsuits or application
Senator
of those
Latz,
requirements.
one other reference that council suggests is on page 2.4, and that would be the similar language after subdivision 3 is listed on that line.
I agree with that and
And that we
incorporate that
should
into my amendment.
incorporate clause 4 and 5 after that point. Senator Ralph, what's your opinion of this?
Mr. Chair, Senator Latz, we certainly feel that that's probably an appropriate approach to try and go back to the limiting language that was available before, and I would consider that as a friendly amendment if we want to do it that way.
All right. Hearing no other further discussion, all those in favor say aye.
Aye.
Opposed? The amendment is adopted.
Thank you, Mr. Chairman.
Senator Latz.
Since I'm on a roll here, I'm going to consider one a roll. On line 17 of page 1, Mr. Carlson made reference to the fact that the response time was settled at 30 days last year in the global agreement to address this issue, but that was at a time when it was a voluntary, not a mandatory notice. So I would agree with Mr. Carlson that it makes sense if there's going to be a mandatory notice and as a consequence a mandatory preclusion of a lawsuit, if there is compliance, that we at least ought to get to the question of will there or won't there be compliance more quickly, and convert that 30 days down to 15 days on line 1.17. So I move to amend the bill accordingly.
Senator Latz moves at on line 1.17, strike the word 30 or the numeric representation 30 to 15 days. Senator Ralph, do you have a comment about that?
Not having thought about the actual period of time, again, the question is are we going to facilitate or hinder the process? I'm not sure that 15 days is going to be enough for a person to be able to respond. And again, on the fly, it's a little bit, I'd like to just contemplate and maybe consult with the stakeholders. Again, we're trying to do some stuff on the fly here that I think there are some people who have a lot of time invested in this that I don't want to upset the apple cart. This was what was in the statute and apparently was agreed upon in the prior year. So before we go and tinker with that, I guess I'd like to get some comment from the stakeholders.
All right. Senator Ralph, I'm going to move on to a comment from Senator Anderson, if maybe you can find someone to discuss this with. Senator Anderson.
Thank you, Mr. Chair. I was going to do the same thing and just ask if the stakeholders could come and just comment on this proposed amendment, because it seems, to me, 15 days seems a little short, but I'd like to hear from those who have been in the midst of this whole situation.
All right.
Again, thank you, Mr. Chair. In looking at this again, I think that here again, Senator Latz brought up a good point last year, that last year we had the limiting sections. This was by agreement. The 30-day was also by agreement, and there was good reason that the committee apparently found that that was a reasonable period of time, and unless we have some evidence to show that that's going to create a problem, I'd kind of like to stick with the 30 days. That just from the information given that the time to investigate is probably appropriate, and I have some additional comments that go further.
Senator Latz withdraws his
okay, thank you.
His amendment.
Mr. Chairman?
Senator Latz.
Yeah, I went back and read that, how it fits in with the time to remedy the violation, and I would agree that 15 days is too short to be able to comply with the remedy provision that's in the bill. I disagree with that provision in the bill, but if it stays in, then you know, it would be too short. That's why I withdrew that amendment. But, Mr. Chairman, I would like to offer another amendment on page 2.
State the amendment, Senator Latz.
All right, on line 2.2, after the word notice, insert under subdivision 2A. That is just a clarification of the cross-reference back to page 1 of the bill.
I'm sorry, Mr. Chair, where was that again?
Senator Ralph, or Senator Latz, could you repeat your amendment for Senator Ralph?
On line 2.2, after notice, before the period, insert under subdivision 2A.
Mr. Backus, would you like to make a comment?
Mr. Chair and members, Senator Latz, I think you'd want to say under subdivision 2, paragraph A. Because,
Either way, or just put A in parentheses, which is the way it's...
Well, we say comma paragraph A, otherwise
fine.
people might think you're referring to a completely different subdivision.
All right, that's fine.
Does everyone understand it? Senator Ralph, do you have a comment?
I think that clarifies the language, so I certainly would not oppose that.
You would consider that a friendly amendment?
Yes.
Everyone understand the amendment? Hearing no further discussion, all those in favor say aye.
Aye.
Opposed? The motion, or the amendment is adopted.
Mr. Chairman?
Senator Latz.
Thank you. Now, Mr. Chairman, I think the whole idea, and this goes to the, I don't disagree that there's an issue here that needs to be dealt with. And we've been working on this issue for a couple of years. I've got Senator Dietzig's bill from last year. We've got what we actually passed in the end last year. There was talk last year about attorney's fees set at $1,500 or $1,000, for example, which would still provide an option. But what I'm very concerned about is the whole idea of just shutting down the opportunity for making corrections. I mean, to me, I found the testimony quite compelling that after 34 years, we still have businesses out there that refuse to come into compliance with the law that they should be in compliance with now. Or they haven't done it. Maybe they never had an audit. Maybe they had an audit, decided they didn't need to do anything. Cost them $750 or $1,000 to come into compliance. They choose not to spend that money and rather wait to see if, one, they get caught, or number two, if they're caught, does anyone raise a stink about it? Because there'll be plenty of people who are disabled that are facing a barrier or an imposition of some sort that simply aren't going to track down a lawyer and try to bring a claim. And unless legal aid or the Disability Law Center are going to start providing free services, going around checking on places to see if they're in compliance, this bill, as we have it before us, will shut down remedies for these kinds of issues, for these kind of architectural barriers. So I'd like to move that on line 2.2. After the word may, we delete not.
Delete the word not.
Delete the word not. After the word plaintiff, delete if within, and insert in its place the word after. On line 3, after the word barrier, insert the word violation. And then on line 4, after subdivision 3, I guess delete the semicolon and replace it with a period. And then delete lines 5 through 15 of the bill. That way, Mr. Chairman, it allows for a civil action to be pursued under the appropriate circumstances and does not, in fact, give businesses the get-out-of-jail-free card, which, and I'm not saying most businesses are, intentionally trying to throw up barriers in front of disabled people. But if the onus, if the law is set up in such a way that they don't have to do anything until they are caught, then they have absolutely no incentive to ever comply with the law unless until someone comes in and complains about the violation and is willing to go find a pro bono lawyer to serve a notice on that business. And that is just antithetical to everything the Human Rights Act is all about. So I'd ask for support for my amendment, Mr. Chairman.
Senator Ralph, your opinion on the
Thank you, Mr.
amendment.
Chair, Mr. Latz. The problem with the Senator Latz's amendment, it guts the intention of the bill. The intention of the bill here is to do two things. One, it's to get the barrier fixed, and two, it's to stop the frivolous lawsuits. By doing this, we're right back where we started. We haven't fixed anything. Now, I certainly acknowledge that it is a bit draconian to simply prohibit lawsuits in the control of the defendant. I agree. I think that may be a bit of a problem. The problem we're dealing with, and I'm not sure that we can solve that here in committee in a 3 or 4 word or delete fix. This was my concern coming in once these became apparent that there were some issues. I think that I agree that there should be some provision that provides incentive to fix the problem, but I think there also needs to be a sufficient method of prohibiting people from just filing a lawsuit and then letting it run wild, even though the barrier has been removed and the party involved has done exactly what the intention of the law was. That is, they've fixed the problem. So we need to balance the intent of getting the barrier removed and the intent of allowing someone who has been damaged by such a barrier to be able to find counsel to bring the action. And there needs to be a balance there somewhere.
Members, we are at the point of leaving this room. If we want to curtail discussion and vote on Senator Latz's motion, we can do that, or we can come back at 7 o'clock tonight. So what would be the choice of the committee? Hearing no further discussion.
I'm perfectly willing to come back at 7 o'clock, Mr. Chair.
Okay, we have one
I don't know about the stakeholders, whether that.
Senator Latz does have an amendment in play. Is there further discussion? Hearing none. All those in favor say aye.
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 Opposed? No. The motion or the amendment is not adopted. We have the remaining of the bill. Any further discussion on the rest of the bill? Yes, Senator Schoen.
Thank you, Mr. Chair. Senator Ralph, just going off of what you said, so do you think that your bill needs to be worked on to deal with, it sounds like you do have some concern about limiting the ability for legitimate lawsuits to move forward. I'm just curious what your thoughts are there.
Absolutely. I'm sorry, Mr. Chair, Senator Schoen. I'm very concerned about removing a legitimate remedy. I mean, if someone has been injured, then we shouldn't remove the remedy for that injury. The problem here is, in part, we're dealing with a violation without injury in some cases. In other cases, as was very clearly put, a 1-inch barrier may be a huge barrier to someone who is disabled. So I am very sensitive to the concept that we are going to completely remove the possibility of a remedy. On the other hand, I do think we need to have, as I've said before, a balance between where the remedy exceeds the damage that's been done and goes far beyond what the intention, I think, of all parties is, and that is to provide access, free access to people who have disabilities in the community. And I am very sensitive to the idea that attorneys are reluctant to bring actions if they're not going to get paid. That's not what we were in the business for. We were in the business for. On the other hand, there is a point in time where the baby does get thrown out with the bathwater, where the lawsuit proceeds far beyond its original intended bounds, and that's the concern that I have.
Mr. Chair, it seems like there's a lot of concern even with Senator Ralph, but I mean, this seems like the things that we're concerned about, this is the committee jurisdiction to fix them. And I mean, it's just the beginning of March. I think we got a little time left of the year. It seems like this should probably be laid over and we should come back to it by his description. I mean, if there's remedies to be made, let's make them. I mean, I've been a co-author on this bill in the past, but I still don't understand sometimes, quite frankly, how these violations get by and who's supposed to catch them in the first place, before they get an occupancy certificate or otherwise. So, I mean, those are the issues where I wonder why this is the remedy versus us dealing with it in a way that they should be dealt with at the local level for starters when they get inspected as well, too. So I think there's a lot of things here that are still left with full of questions.
Thank you, Senator Schoen. Senator Ralph renews his motion that Senate File 1407 be recommended to pass as amended and move to the Senate floor.
Mr. Chairman.
Senator Latz.
I had a question for Senator Ralph. Senator Ralph, how do you perceive that attorneys are going to be in a position to prepare these notices and send them if your bill becomes law?
I'm sorry, your last...
Senator Ralph.
How do you perceive that attorneys are going to be in a private attorneys are going to be in a position to prepare these notices, investigate the allegation, prepare the notices, send the notices, and do any follow-up if your bill becomes law?
As it stands now, I believe that that is a concern. The only thing that I can say is that in the interest of getting this moving forward, I would certainly commit to deal with that. And that, unless we want to come back tonight and continue to discuss it, which I certainly am willing to do if the committee is. I understand that this is taking a lot of committee resources, and am trying to work on the fly with this. I concur in the concern, and I do believe that there is a work through that we should be willing to look at to avoid the unintended consequence here. But at this point in time, I think we've kind of reached a little bit of a barrier, pardon me, to trying to get this done, and that is we're up against a time barrier.
Sir Ralph, I'd like to remind the members that in 2016, a Senate File 2584 passed this committee in substantially identical form to this bill, just as a note.
Mr. Chairman.
And yet there were amendments that Senator Latz added to the bill today. Senator Ralph renews his motion. Senator Ralph, or Latz. Senator Latz.
I don't recall, I can take a look, and I'm sorry to take up more committee time with this, but I don't recall that that the bill that was passed in 2016 mandated a notice. It allowed for notice. I don't think it mandated notice. And then as a consequence, here you've got not only got a mandated notice, but you've got a mandated no more lawsuit if the barrier is removed. So that's a pretty substantial difference, Mr. Chairman. And with all due respect to Senator Ralph, who's new to this issue, the party's been working on this for a year or two. Coming back tonight isn't going to give enough time to noodle around the question of how do you deal with unintended consequences. Unintended consequences of throwing a barrier to all lawsuits relating to these kinds of issues, that's a pretty big consequence because, you know, this thing needs more work. And what Senator Ralph is asking this committee to do is pass a bill that even the chief author acknowledges is not ready for enactment into law, and to divest this committee of jurisdiction over the issues. We're talking attorney's fees here. There's no other committee that has anywhere near jurisdiction over attorney's fees in this body. But we're being asked to pass a bill and pass that issue along to some future committee to deal with it, or the floor to deal with it. And I can tell you this is going to be one heck of a mess on the floor if some of these things aren't ironed out now. So, I mean, if it's going to be the committee's choice to just pass whatever it feels like passing that even the chief author acknowledges is not ready, and let someone else in the legislature deal with judiciary issues, and I think it's a really bad precedent to set.
Mr. Chair, if I had a choice, obviously we would like to continue and have a clean bill to go to the floor. But unless we can get to that point, I am very concerned that this legislation gets delayed another year, and we have to face the same problem that we've been facing for many years. So if we cannot come to an agreement as to either go meet later and work on this, then I would move that we pass the bill and we work on it until it gets to the floor, and I commit to do that.
Senator Ralph renews his motion that Senate Bill 1407 be recommended to pass as amended and be recommended to be sent to the Senate floor. All those in favor say aye.
Aye.
Opposed? No. The motion prevails.
Thank you, Mr. Chair.
Members, Senate File 809, another bill on the agenda will be rescheduled for later this week. We stand in adjournment.